Now we come to the, let's say, most crucial, dare say, points raised in the agreements, in these transfer agreements, which are the intellectual property issues collectively. And when we talk about intellectual property issues, we talk both about the copyrights, but as well the industrial property rights, which means practically patents. So these copyright issues and the acknowledgements based on the contribution are of significant importance when it comes to MTAs. Usually, and this is the vast majority of the cases, when it comes to transfer of material data, the thing expected to come out of a research is most commonly a paper, a scientific paper. So there are specific terms where the acknowledgement issues are articulated into extent, and also the publishing party has some obligations. The obligation, the most important one, to reassure that the rights of both parties are protected, is the obligation to transmit any material intended for publication to the other party for a prior review. And this can vary between 20 to 30 days. We have seen even less days, but I expect this period of time, 20 to 30, to be pretty good period for the parties to include in their agreements. In case of objection, parties must resolve disagreement before publishing, and I say that quite, must resolve. It's quite intense, perhaps, to say that they have to resolve the disagreement, but this is a necessity by circumstances, in the sense that if they do not resolve the disagreement, they cannot publish freely, and then issues, legally speaking, issues of IP protection will come further on. So it is advisable that they resolve all these disagreements before publishing. The new IP deriving from material can be owned by both the provider and the recipient in shares proportionate to their contribution to the creation. So now we go further into analysis of the industrial property rights, which means the patents and the inventions that will be produced during this agreement. To this extent, the record keeping is of significant importance for the researchers to know what exactly work they have done and what is their contribution and their inventional, the novelty that they have produced. So in the case of new knowledge, which is patentable, the details of shares of the patent among inventors are to be finalized as a separate intellectual property agreement, and after, of course, the new knowledge is produced, but before the time when the patent is actually applied. And it doesn't make any difference if the patent application is a national or is a European. We can go for a national application or an EPO application, or even an international, a PCT application. These agreements need to be in place before the patent application, so that all the issues, the industrial property issues, are resolved among the inventors before filing for a patent. The negotiation phase, yet again, is not to be done by researchers, or at least not to be done by researchers themselves. My personal point of view from my experience so far is that the researchers need to be part of this negotiation phase, as well as we explained before, at the general phase of setting in force the MTA and drafting an MTA, but this is not the job of a researcher to do. This is the legal department, and depending on the case, the technology transfer office that will be negotiating. Other important elements included are the termination of the agreement. It can be as long as the parties agree. Usually it's for 1 year, but we have seen MTAs that are for more years, like 2 or 3 years. But the vast majority of MTAs is just for 1 year. The dispute resolution is another term which is of significant, again, importance as well. The mediation or the arbitration can be chosen instead of going to the tribunals, which have all the disadvantages that we all understand. And when it comes to jurisdiction, parties may choose the country whose jurisdiction shall apply, or they have the possibility to choose silence of law, as we say. That means to remain silent on jurisdiction. And in this case, international private law, rules do apply. The term that the agreement supersede any prior agreements, either written or verbal agreements, is advisable to be included in these agreements. And the term that the agreement may be executed in counterparts and may be exchanged by electronic mail, but that all probably executed counterparts will constitute one document, is again important now that we have so many agreements between countries, between institutions from Europe and third countries. So it really makes our lives easier to have this term that this can be executed in counterparts and exchanged by electronic email. Some years ago, it was far more difficult. Now with the PDF and scanning signatures, it's by far more easy to go on and execute an agreement like that.